So my people are just bust out to. I tell them before they know, yeah. Now see problem everywhere. They call the hide. They call the hide. Tinubu wahala. Oh God. APC see wahala one another. As now they try hide, now they block this hole. Another hole you open. Now they block this hole. Another hole. When I say on a drug case, the thing don't expire. So it don't last 10 years. Say because now so it done for tribunal court. More than year now. Say it never expire. More than a year now because normally who put her for nyama is not supposed to be president. They're supposed to disqualify her. More than watch this video, be there in the house. Hit the like button, comment your opinion and share. Make sure you share this video because you know why? As it is sweet us, now so it could depend them.
So Tinubu's lawyers are now trying to hide behind subsection 1E of section 137 of the Constitution of the Federal Republic of Nigeria to say that Tinubu's US drug case has a statute of limitation of 10 years. But this is simply not true, because a look at subsection 1E of section 137 reveals that that particular subsection is related to cases that were handled by the Code of Conduct Tribunal, matters relating to the Code of Conduct Bureau, matters and cases handled by the Code of Conduct Tribunal, where public officers, if found guilty, are restricted from holding any public office within a space of 10 years. This case, this US case, this drugs case that is linked and connected to Tinubu is not a case that was handled by the Code of Conduct Tribunal. It was a case that was handled in a US court, far away in the United States of America. So subsection 1E does not apply to it. Subsection 1E for emphasis only applies to cases that were handled by the Code of Conduct Tribunal, and public office holders who are found guilty of falsely declaring their assets or going against the Code of Conduct, Nigeria's Code of Conduct. Those public officers are given a ban of 10 years that stops them from holding public offices for a space of 10 years. That does not apply to subsection 1E of section 137, which actually talks about sentence of fine or imprisonment for fraud or dishonesty related offenses. So stop hiding behind section 1E, subsection 1E of section 137, please. It does not apply. Now, for those saying that the US consular actually cleared Tinubu, it's not true. This case against Tinubu was conducted by an IRS agent, Special Agent Kevin Moss. It was handled by an IRS agent who collaborated with the DEA, Drugs Enforcement Agency, and the Federal Bureau of Investigation. So the lead files, the case files, are with the IRS. The case files are with the IRS. If there were to be any arrest, it would have been handled by the IRS. So the FBI cannot have the case files of the DEA in their database. They cannot. And secondly, the FBI would only have the records of Tinubu in their NCIC if Tinubu had been arrested. And don't forget that the letter that Tafa Balogun wrote asked to clarify if Bola Ahmed Tinubu has a warrant of arrest. It's clearly stated there. A warrant of arrest or criminal arrest record. Tinubu was not arrested, and there was no warrant of arrest that was issued on his behalf. The case was dispensed of by a plea bargain. So a warrant of arrest would not have been issued, and a criminal arrest could not have been conducted. So if a criminal arrest was not conducted and a warrant of arrest was not issued, how will that information be in the FBI's NCIC database? It won't be. So the questions that Tafa Balogun asked was wrong. In fact, what Tafa Balogun needed to do was go to the court and ask for a certified true copy, and he would have had all the information he needed. So that letter from the US Embassy of the United States of America in Lagos did not clear Tinubu of any wrongdoing. What is paramount, or what is of more importance, is the certified true copy of the court proceedings and the orders that were issued, the seizure warrants, the forfeiture warrants, the forfeiture order. Those were the important things, and those have certified true copies. And so that actually overrides anything that the FBI would have said about Tinubu, particularly when the police actually asked the wrong questions. So Tinubu is guilty of being in possession of monies that represented proceeds of narcotics trafficking, and he was fined $460,000, which makes him guilty of a sentence of fine, and therefore by section 137 subsection 1D does not qualify to run for office of president of the Federal Republic of Nigeria. All you supporters of Tinubu should stop trying to deceive Nigerians. There's no correlation, no relationship, no correlation between subsection 1E that you're trying to hide behind and subsection 1D of section 137. The case was not handled at the Code of Conduct Tribunal, so subsection 1E does not apply. The case was handled in a court, so subsection 1D applies. Right? Stop trying to deceive Nigerians. That's all that you're trying to do in your response to the petitions at the PEPC, the Presidential Election Petitions Court. Stop it. Nigerians know better. We're not as dumb as you think. Many may be quiet, but doesn't mean that they don't know.